Honourable colleagues, I stand today to speak to Motion 13 presented to this chamber by Senator Yuen Pau Woo, proposing, quote, that in light of findings and orders from the International Court of Justice and the International Criminal Court on the situation in Gaza, the Senate call on the government to examine the risk to Canada and Canadians of complicity in violations of international humanitarian law, including war crimes, crimes against humanity, and genocide, and to report on its findings within 3 months of the adoption of this motion. My goal in speaking to this motion is to look more closely with you at the framework of the international rule of humanitarian law, and to encourage colleagues in this chamber to see that the inquiry recommended in this motion is worthy of this chamber and worthy of the Government of Canada, if only to back up years of frequent references by Canada's cabinets and diplomatic corps affirming Canada's commitment to defending and upholding the international rule of law. This motion is respectful of the words of Canada's representatives on the world stage, and this motion returns to this chamber the opportunity to invite Canada to match the standards set in these words with responsible self-examination. I invite you to join me as I look briefly at some key components of the international rule of humanitarian law, of which Canada speaks as a defender, that are implicit in Senator Woo's Motion 13. The case of South Africa versus Israel. The International Court of Justice, or the ICJ, is the United Nations Court, composed of 15 judges elected to 9-year terms of office by the United Nations General Assembly and the Security Council by voting simultaneously but separately. In order to be elected, a candidate must receive an absolute majority of the votes in both bodies. Judges must be elected from among persons of high moral character who possess the qualifications required in their respective countries for appointment to the highest judicial offices, or are jurists of recognized competence in international law. The court may not include more than one national of the same state. Moreover, the court as a whole must represent the main forms of civilization and the principal legal systems of the world. Once elected, a member of the court is a delegate neither of the government of their own country nor of that of any other state. Unlike most other organs of international organizations, the court is not composed of representatives of governments. Members of the court are independent judges whose first task, before taking up their duties, is to make a solemn declaration in open court that they will exercise their powers impartially and conscientiously. The current court is made up of judges from Australia, Brazil, China, France, Germany, India, Japan, Jordan, Mexico, Romania, Slovakia, Uganda, and the United States. The case before the ICJ on the issue of Palestine and Israel is known in short form as South Africa versus Israel, and the full title is Application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip. South Africa is far from alone in asking the ICJ to examine the Genocide Convention, joined by several dozen other countries, including Ireland, Spain, Brazil, and China. So far, the ICJ has ruled on several provisional measures directing Israel to halt its offensive in Rafah and to ensure basic measures such as food, water, and clothing are available. Almost 2 years ago, quote, in the order of 26 January 2024, the court also found that at least some of the rights claimed by South Africa under the Genocide Convention and for which it was seeking protection were plausible, namely the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts mentioned in Article 3, and the right of South Africa to seek Israel's compliance with the latter's obligations under that convention, end of quote. The court went on to state, quote, in conformity with its obligations under the Genocide Convention, Israel must immediately halt its military offensive and any other action in the Rafah Governorate which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction, in whole or in part. In addition to South Africa's case before the ICJ as the UN court, the United Nations General Assembly, or UNGA, the governing body of the United Nations, with 193 member states, requested an advisory opinion from the court on its obligations in terms of the genocide in Palestine. And on 19th December 2024, UNGA adopted the advisory opinion, which assessed the evidence of genocide in Palestine. The court concluded, quote, the state of Israel's continued presence in the occupied Palestinian territory is unlawful, and the state of Israel is under an obligation to bring to an end its unlawful presence in the occupied Palestinian territory as rapidly as possible, end of quote. This advisory opinion from the ICJ also laid out the legal consequences for UN member states if they are complicit in the genocide. Israel did not consent to the jurisdiction of the court to give this advisory opinion. However, the court retains jurisdiction to give this opinion because it is not a bilateral dispute, but an advisory opinion on legal consequences requested by the UN governing body, UNGA. The court noted that since Resolution 181(2) in 1947, the General Assembly has had a permanent responsibility towards the question of Palestine. The court also found that the Security Council does not have exclusive jurisdiction under the United Nations Charter to address issues of international peace and security. The court summarized the work done by the United Nations and the International Criminal Court on the International Court of Justice on the question of Palestine and Israel since 1947, noting that since 1967, Israel has been constructing illegal settlements in Palestinian land, concluding that, quote, all legislative and administrative actions taken by Israel to change the status of the city of Jerusalem, including expropriation of land and properties, transfer of populations, and legislation aimed at the incorporation of the occupied section are totally invalid and cannot change that status, end of quote. In its opinion to the UN General Assembly, the International Court of Justice found, and I quote, the fact that an occupation is prolonged does not in itself change its legal status under international humanitarian law. Although premised on the temporary character of the occupation, the law of occupation does not set temporal limits that would, as such, alter the legal status of the occupation, end of quote. With regard to the right to self-determination, the court considers that While it is for the General Assembly and the Security Council to pronounce on the modalities required to ensure an end to Israel's illegal presence in the occupied Palestinian territory and the full realization of the right of the Palestinian people to self-determination, all states must cooperate with the United Nations to put those modalities into effect. As recalled in the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations, states, quote, "Every state has the duty to promote, through joint and separate action, realization of the principle of equal rights and self-determination of peoples, in accordance with the provisions of the Charter, and to render assistance to the United Nations in carrying out the responsibilities entrusted to it by the Charter regarding the implementation of the principle," this being General Assembly Resolution 2625. Now I'd like to turn to a brief discussion of the International Criminal Court. Canada contributed significantly to the Rome Statute that created the International Criminal Court. This is not a UN court. It is an independent, permanent court of last resort with jurisdiction to investigate and prosecute the most serious crimes of international concern, namely genocide, crimes against humanity, war crimes. Canada became the first country in the world to incorporate the obligations of the Rome Statute into its national laws when it adopted the Crimes Against Humanity and War Crimes Act. On 21st November 2024, the ICC issued warrants for the arrest of Israel's Prime Minister, Mr. Benjamin Netanyahu, and Mr. Yoav Gallant for war crimes and crimes against humanity. The extensive evidence cited by the court includes, and I quote, "The effects of the use of starvation as a method of warfare, together with other attacks and collective punishment against the civilian population of Gaza, are acute, visible, and widely known, and have been confirmed by multiple witnesses interviewed by the Office of the Prosecutor, including local and international medical doctors. They include malnutrition, dehydration, profound suffering, an increasing number of deaths among the Palestinian population, including babies, other children, and women. Israel," I'm going on to quote, "Israel, like all states, has a right to take action to defend its population. That right, however, does not absolve Israel or any state of its obligation to comply with international humanitarian law. Notwithstanding any military goals they may have, the means Israel chose to achieve them in Gaza, namely intentionally causing death, starvation, great suffering, and serious injury to body or health of the civilian population, are criminal." End of quote. I'll now return to Senator Woo's Motion 13 to note that the central concern is that Canada and Canadians are being placed at risk of being found to be accomplices or allies in what is increasingly being seen as a genocide under international rule of law. Up until recently, Canada, confirmed by Global Affairs Canada, was still supplying Israel with arms and weapons parts. Only last month did Canada's Prime Minister recognize Palestine as its own state, despite Canada supporting the United Nations' decades-long call, consistent with the 1947 two-state solution, stipulating the creation of two separate states. In essence, This motion calls on senators to urge the Government of Canada to dedicate attention and resources to mobilize expertise of lawyers, scholars, and experiential authorities to examine the degree of risk.
Senator McPhedran. Senator McPhedran, the time allowed for debate has expired.
Thank you. May I have 60 seconds?
Is leave granted, honourable senators? Agreed. Senator McPhedran.
Thank you very much. As the United Nations and International Court of Justice continue to find violations of international humanitarian law by Israel, Canada needs to ensure that it is complying with its international obligations as a member state under treaties that Canada has signed and ratified, treaties that make up the international rule of law, including the Genocide Convention. Thank you. Merci. Miigwech.
Senator Housakos.
Would the honourable senator take a question?
Well, I believe she asked for 60 seconds. Leave was granted unless Senator McPhedran asked for more time for the question.
If the chamber permits.
Is leave granted, honourable senators?
Agreed.
Senator Housakos.
Thank you. I'll try to be brief because a lot of things have been said on this issue in this debate, and there's a lot of revisionist history. So my question, Senator McPhedran, and you're, I think you're a learned person. You definitely understand the history and the importance of history to things. So my question is the following. Modern-day Gaza was under colonial rule by the British prior to 1948. Before that, for hundreds of years, it was under Ottoman rule. Before that, before the word Palestinian ever existed in the lexicon of the Hellenic people who occupied that part of the world once upon a time, and the Philistines, and they invented the word Palestinian ever existed. Can you tell me at what portion in the history of mankind was there ever a Palestinian state established, self-governed, and recognized by the international community?
Senator McPhedran.
Thank you very much for the question, Senator Housakos. And as much as I enjoy the long-range historical overview, let me begin in 1947 with the United Nations and the international law establishing a Palestinian territory, and also the recognition of the State of Israel. And everything that I said in my speech, mostly quoted from judgments, makes it clear that the existing international humanitarian law, to which Canada has signed on and been a leader in many ways, is being violated in the opinion of the world's experts, the world's judicial experts. Now, Senator Housakos, we've had some conversations about the UN. I know it's not your favorite place. However, it is the existing organization to which Canada over and over again has respected, signed treaties, made commitments, and in particular has promised to uphold international rule of humanitarian law.